Chapter 7, Ownership of Real Estate. The last chapter, chapter 6, we were talking about estates and interest in land. That's the kind of interest that you have when you own real estate. What kind of interest you have. In this chapter, we're talking about ownership interests. That's when you have ownership, is it by yourself? Is it with someone else, etc.? So in this chapter, we're going to go over the different types of ownership interest in estates. And without further ado, we're going to describe different forms of ownership and explain the differences between condos, co-ops, and timeshares. And we're going to learn what those things are. We're going to start off with tenancy in severalty. Sounds like more than one, right? Severalty. When you say several, severalty sounds like more than one. But it comes from the root word is not several in severalty. The root word is sever. So when your interests are severed, they're cut off from all others. That means sole ownership by one person or entity. So tenancy in severalty is ownership by one person or entity. Your interests are severed from all others. So that root word is sever and not several. Sole ownership by one person or entity. The owner is free to devise the property to anyone they like in a will. They're allowed to decide who gets the property when they die, even. So let's highlight sole ownership or tenancy in severalty. This term means that all interests are severed from others. When a person dies, title to the property passes to their heirs, those are their natural blood relatives, or their devisees, those they name in a will, who they want to direct to get the property. Just highlight that. Let me know when you got it.
Got it.
Got it.
Okay. So remembering legal terminology, here on page 120, you got a chart like this. Above where it says person giving the product, write OR in capital letters with quotes around it. And where it says person receiving the product, write EE in capital letters with quotes around it. So as long as you know the root word here, or they describe it as the product, this is the root word. As long as you know what the root word means, if it has an OR at the end of it, that's the person who's giving that product, that root word. And if the word ends in EE, that's the one who's receiving that product. So devise is when you die and you name someone in a will to get your stuff, or you're leaving the property to someone in a will. That is called devise, leaving property to someone by will upon death. Devise. So therefore, the devisor is the one who's leaving you that property in a will upon their death. And the devisee is therefore the one who is named to receive that property. You get it? It makes learning a lot of this terminology a lot easier to understand. Like you guys all know what a lease is, right? A lease is a document where an owner intentionally conveys their property to a tenant for a limited period of time, as defined in the lease, along with all of the rights that the owner of the property has, except for the right to sell it or mortgage the property. So therefore, the one who gives the lease is the lessor, and that would be who? The landlord gives you a lease. So it's the lessor who gives the lease, they're the landlord, and the lessee is the tenant who gets the lease. See, doesn't this make it a lot easier to be able to identify the characters? Who the players are with this new terminology, lessor, lessee. Otherwise, some people get confused in these things. But as long as you understand the words that end in OR is the one who's giving whatever the root word is, and the one that ends in EE is the one that's receiving whatever it is, it makes it a lot easier to understand. So a lease We all know what a lease is. Who gives you a lease? The landlord. And that would be the one that ends in OR, the lessor. Okay, it makes it a lot easier to understand the players. Okay, so we back it up. Devise is given a property to someone by upon death in the will, right? Grant, anytime someone gives you property or sells you property, they're granting their ownership to you. So the grantor is the one who's given the ownership, grantee is the one that's receiving it. Legacy is your personal property that you've amassed during your life. The legator is the one who's giving you that property. Legatee is the one receiving it. We just went over lease. Mortgage got a little asterisk next to it because it's the opposite of what most people think that it is. Most people think that a mortgage is a loan. No, no, no. If you have that word after it, it can be a mortgage loan. But the word mortgage itself is not a loan. The word mortgage is a promise to pay. And you give that promise to pay, and in exchange, a lender gives you a loan, money, cash, right? So, what is that promise saying? That promise is saying, hey, lender, if you lend me your money, I'll pay you back according to the terms that we've agreed upon in the note. The interest rate, the frequency of payment, and all of that. So the mortgage is a promise to pay. Banks don't make promises, they make loans. So therefore, who's making the promise to pay if they get a loan? The borrower. So the mortgagor is the borrower. So that's probably an easy way to remember it, to sing it. Instead of trying to go through that whole thought process that, banks don't make promises, they make loans. It's the borrower who promises the lender. And if they make the promise to the lender, they'll pay them back. In exchange, the lender gives them a loan. So therefore, the mortgagor is the borrower. That's too much thought process. I like the KISS concept. You guys all know what that is. Y'all heard of the KISS concept before? Keep it simple, stupid. Don't make me think. Keep it simple, stupid. So the mortgagor is the borrower. Say it, sing it. The mortgagor is the borrower. Okay, and you can't forget it. It's like simple, stupid. You don't even need to think about the process and how it works because it rhymes. The mortgagor is the borrower. Just sing it. That's it. And then boom. I doubt they're going to ask you a question right on an exam. I mean, they could, but I doubt they're going to ask you a question just straight up, who is the mortgagor? It is the borrower. I mean, they could ask you a question like that, but most likely they're going to give you some long-winded question and they're going to use some of these terms in them. And if you can't figure out what those terms mean, and especially when they use multiple terms in their questions, you're going to get lost in what the hell they're asking of you. So this is why we need to understand so much of the vocabulary. So when they give us the questions, we understand what it is that they're asking of us, and it makes it easier to answer. So the mortgagor is the borrower, and the mortgagee, well, that's the lender. That one don't rhyme. So sorry. Another way to remember it is mortgagor has two O's in it, borrower has two O's in it, mortgagee has two E's in it, lender has two E's in it. That's just another way. But for me, that's still too much thought. I like the mortgagor is the borrower. You can't forget it. Is my annoying voice stuck in your head yet? The mortgagor is the borrower. It works. It sounds silly, sounds stupid, but this kind of nonsense ways to remember things actually does work. You'll see. You guys will appreciate it later on when you see it on an exam and you're like, mortgagor is the borrower. All right, you guys get the idea with all this stuff now. All right, so now that we understand how words that ending in OR versus words and ending in EE works, okay, here's just another slide I put together of the same stuff with the explanations down here about the lease and the mortgage. All right, look, even lenders misuse these terms. Take a look at this LendingTree commercial where the lender is misusing the terms mortgage. So it's no doubt that the public, it's no shock that the public is going to not really know what it generally means either. but they're not out there to educate you. They're out there to sell you loans, right? So they do it in a way like this.
Looking sharp, Len. Who's the lucky lady?
I'm going to the bank to discuss a mortgage.
See, you need a loan, you put on a suit, you go crawling to the bank. This is how I dress to get a mortgage.
Hold on a second. If you're the borrower, you don't get a mortgage, you give a mortgage. Because what is a mortgage? It's a promise to pay. In exchange, banks give you loans. So even this lender is misusing the term in their commercials. They're not there to educate you, they're there to sell you a loan. If you're there correcting people all the time, you're not going to sell anything, right? So they're misusing the term.
Just go to Lending Tree. I calculate how much home I can afford. I get multiple offers to compare side by side. And the best part is, the banks come crawling to me.
Everything you need to get a better mortgage. Clothing optional. Lending Tree. When banks compete, you win.
Okay.
Awkward.
Interesting commercial. I should approach Lending Tree to start sponsoring this class since I play this commercial in every class for them. All right, so let's see the different forms of ownership again are tenancy in severalty, tenancy by the entirety, tenancy in common, and joint tenancy. These are the four types of tenancy we're going to go over. So tenancy in severalty comes from the root word sever. Your interests are severed from all others, so it's ownership by one person or entity. Tenancy by the entirety, this is ownership by married couples. They own the property entirely together. Tenancy in common is the default form of ownership when you have two or more owners not married to each other. That's tenancy in common. Or joint tenancy, if you want another type of tenancy other than tenancy in common, you have two or more people who are not married to each other, you could have joint tenancy as a form of ownership. However, in order to create a joint tenancy, you have to specify you wish to take ownership in this form. There have to be four things in common, which they call unities, four unities in common in order to create a joint tenancy. And corporation can never own as a joint tenant because the only benefit to having joint tenancy, it's sort of like the last man standing, so to speak. So whenever one co-owner dies off, the surviving co-owners automatically equally split the shares of the owner who died. And it doesn't need to go through probate or anything. It's automatic. Now, I'm going to teach you about these four types of joint tenancy inside and out, so you guys should be able to study them and understand them so well. And you're going to study your little hearts out. You're going to be ready for exam. Be careful on exam how they word questions. If they word it in a way that they're asking, how would the real estate licensee advise that someone should take ownership? You would select none of the above because that's legal advice and we're not attorneys. We don't give legal advice. So that would have been a trick question if they ask it in that way. But if they ask which form of ownership would this be in this situation, well, that's different. Then you need to be able to identify the different forms of ownership. So don't get caught in that trick, okay? I'm just showing you the little tricks that they use there. So let's get into it and learn about these four types of ownership. We already started off with tenancy in severalty, which comes from the root word of sever, and your interests are severed from all others. So it's ownership by one person or entity. An entity is an artificial person for tax filing purposes. So they get tax ID numbers in businesses too. Now, if you have more than one owner, the default form of ownership is tenancy in common. Or in the commercial real estate world, they use an acronym TIC. It's a TIC, tenancy in common. So this is you notice I wrote in here, default form of ownership. It's the default type of ownership, the default form of ownership. When two or more people or entities own property, they do so as tenants in common. says in tenancy in common, each owner has an undivided interest in the whole property. So basically, say that you're a 25% owner. It's impossible to say which 25% of the property is yours. You have 25% interest in the entire property. It's not like, oh, that's your corner over there. Okay. And although a tenant in common may hold, say, 1/2 or 1/3 interest in a property, it's impossible to distinguish physically which specific half or third of the property is owned. So that's the way that they explain that. And tenants in common do not necessarily have equal shares. You can have unequal shares of ownership interest with a tenancy in common. When we talk about joint tenancy, you're going to learn that one of the 4 unities is all the co-owners must have equal ownership shares. Tenancy in common, they don't. So in a tenancy in common, each owner can sell, convey, mortgage, or transfer their interest without the consent of their co-owners either. And upon the death of the tenant in common, their interest passes to their heirs or devisees that they name in a will. If a tenant in common wants to dissolve a co-ownership, but the other parties do not voluntarily agree to its termination, he or she may file a suit in court to partition the property. That means to divide the property if it's physically possible into different deeded lots. But if that's not possible to do, the judge will just order the property sold, and then each party will get their share of the proceeds from that sale. Unless they want to buy that person out who wants out. If they can't or don't want to do that, the judge is going to order that property sold. They don't got to be stuck owning it with you. So therefore, it is a form of involuntary alienation. That's why I got that underlined here. It is a form of involuntary alienation. That could be an exam question. Which one of these is a form of involuntary alienation? They have the word partition. So in New Jersey, a conveyance of 2 or more persons not married to each other creates a tenancy in common, unless otherwise stated in the deed. And the tenant's shares would be equal unless otherwise described. So let's just say that you and I buy a property together. And you put up 75% of the cash and I only put up 25% of the cash. We're 50-50 owners unless you specify in the deed that you're 75% and I'm 25%. You think it's an important detail to make sure it gets added? I'd say. But if you don't, if you forget, we're 50-50. Let me know when you guys have all of those highlights and underlines.
Got it.
Everybody else good too? Or still highlight? Okay.
I'm good.
Good.
All right. So tenancy in common, here's the breakdown of the details of tenancy in common, the TIC. It's the default form of ownership when there's 2 or more people or entities not married to each other. It automatically creates a tenancy in common unless otherwise specified in the deed that the ownership's to be taken in another form. A corporation can be a partner with a partial ownership interest in the property. Each owner can have unequal ownership shares of interest in the property. Example, one can be 25% owner, another 75% owner, but if not stated in the deed, you're 50-50. Owners can devise their interest. They can leave it in a will to anyone. And they can sell their interest without the permission of their co-owners. This is something that I put a little note here in the middle about. Licensees must use caution when selling only a partial interest from one owner. It could be classified as a security, and you'd need a special license to deal in securities. Also, with real estate license as well, you would need because it is real estate you're selling. So it's not enough just to have that securities license to sell securities, but you'd also need a real estate license. So unless you have both of those licenses, or you partner up with somebody who has the other license, be careful about trying to sell anything like this. In most cases, it is deemed a security, and you need special licensing to sell only one party's interest in a property instead of selling the entire property with all parties on board to sell it. You got it? The instance of when it would not be considered a security is so minute, it's difficult to comprehend and understand in the eyes of the IRS's definition. So I just tell people that, hey, listen, if you're selling just a partial ownership interest, chances are it's a security. So unless you got somebody else involved with a securities license, don't take that as a listing to try to sell only one person's ownership interest, because it's most likely going to be a security, and you need to have both a real estate and a securities license to sell them. Now, owners have an undivided interest in the entire property. You cannot physically distinguish which part of the property is yours and which part of the property is mine. We're not drawing a line down the center of the property, and that's my side and that's your side. If you're 50% owner, you're 50% owner in the entire property, not this is my side of it and that's your side. And unless you buy out your partner's interest, you'll never own it in severalty. When one co-owner wants to sell and the others don't, you could ask them to buy you out, or you could try to sell your interest, but that may be difficult to do. Or lastly, you could partition the property, take them to court, see if the court can physically partition it. If that can't be done, they'll order the property sold. Yes, so you're suing your partner to get out of the deal. So I have the definition down the bottom. A partition is a court proceeding where one co-owner sues the others, forcing them to divide the property if physically possible or sell it. This is a form of involuntary alienation. So this slide is my definition and my breakdown of the details of tenancy in common versus what you just highlighted here on this slide. I got it broken down and explained a little bit further. So if you want to snap yourselves a picture, get a screenshot, whatever, do so.
Got it. Thank you.
You're welcome. Now we get into joint tenancy, because we know that tenancy in common is the default form of ownership when you have two or more owners that are not married to each other, unless you state otherwise in the deed. And what would you state otherwise? Joint tenancy. So this is two or more people can also choose to own property as joint tenants. You'd have to choose. Otherwise, the default form of ownership is tenancy in common. So when two or more people not married to each other choose to own property as joint tenants, the main feature of joint tenancy carries with it something we call the right of survivorship. That basically means that if one of the co-owners dies, the surviving co-owner or owners will automatically equally split the shares of the owner who had died. That's why I refer to it as the poor man's will. Now, a joint tenants, let's see, two or more people, not entities. A corporation can never be a joint tenant, can never have an ownership share as a joint tenant, because corporations never die. They need to get these formally dissolved. And usually if like the president or CEO dies, the corporation don't die. They just replace them with someone else and the corporation lives on, right? So it would always be that last man standing, so to speak. So that's why a joint tenant a corporation can never be a joint tenant. Make sense? Yeah? No? Confused?
Yes.
Okay. Don't worry, we'll get into this a little bit more. I'm going to break it down more. For joint tenancy, Eventually, as all the co-owners die, ownership is divided equally among the surviving co-owners, which will eventually leave one person standing and being the owner in severalty through the process called the right of survivorship. That is, of course, unless somebody breaks the joint tenancy. Well, how do you break a joint tenancy? Well, to know that, we first need to know what are the four unities in order to create a joint tenancy. And there are four unities required to create a joint tenancy, and there's a little acronym I'm going to give you here, TTIP. It stands for the unity of time, title, interest, and possession. Now we'll go over that in just a second. Let's just first highlight this statement that says on page 121 that says to create a joint tenancy in New Jersey, language in the deed must expressly state that you wish to take ownership in this form. Because if you don't, what form of ownership is it? Two or more people not married to each other.
Tenancy in common.
Tenancy in common. Unless you state otherwise in the deed. And what would you state otherwise? You would state joint tenancy in this situation here. So there's four unities required to create that joint tenancy. The unity of time, title, interest, and possession. Now, the book didn't put them in that order. I am, because that's the easiest way to remember it. TTIP, time, title, interest, and possession. They got it all jumbled up over here for some reason in this edition book. They got possession, interest, time, and title. So they got it a little backwards here. So let's go over what these four unities are. The unity of time. All joint tenants must acquire their interest at the same time. The unity of title. All joint tenants must acquire their interest by the same deed to convey those interests. The unity of interest. All joint tenants hold equal ownership shares. So you can't have one person that's 25% owner, another one that's 75% owner. They all have to have equal ownership interests. If they do not, it is not a joint tenancy. Or you broke the joint tenancy somehow. And then lastly, possession. All joint tenants hold an undivided possession of the property, where if you do have 50% ownership, you can't tell which side of the property is mine and which side is yours physically. You have 50% ownership in the entire property. It's not this side of the building is mine and that side of the building is yours. It's not how it works. You have 50% ownership of the entire property if it's 50-50. So I further go on and give that explanation down here at the bottom of this slide in case we forget that. What is possession? It means you cannot physically distinguish which part of the property is owned by an individual. If you're 50% owner, you own 50% of the entire property and cannot physically distinguish which part is yours versus a co-owner's. Okay?
Got it.
Yep, so above the title, joint tenancy. Well, we had that on another slide, didn't we? Yeah, we wrote this stuff in there and you guys had that. And then this is creating joint tenancy at the bottom of page 121. You wrote the four unities required to create joint tenancy, TTIP, time, title, interest, and possession.
Yes.
Okay. Everybody got it? Yes, no? Very good.
Got it.
Good.
All right, so now I put together a slide breaking down all the details of joint tenancy. Two or more owners, usually not married to each other. A corporation can never be a joint tenant because of its perpetual existence. Corporations never die, they live on forever until they're formally dissolved. Now, to create a joint tenancy, it must be specified in the deed you wish to take ownership in this form. Otherwise, you own as tenants in common. The only benefit to having a joint tenancy is the right of survivorship. That's a term you need to know and add to your definition list as well. What is a right of survivorship? It means if one co-owner dies, the surviving co-owner or owners automatically equally split the shares of the owner who had died. I know, I get people in class sometimes. What if they all died in the plane crash together? How do you determine who died first? Who gets it? Well, if everybody should die at the same time, I did some research on this, some legal research. It reverts back to tenancy in common. Then each party can, their heirs can inherit it, their shares. Now, all owners must have equal ownership shares in the property. All owners hold an undivided interest in the entire property where you can't physically distinguish which part belongs to who. Each owner can sell their interest without the consent of the other co-owners. This would, however, destroy the joint tenancy, converting the new owner's interest to a tenancy in common. However, the existing co-owners, if there are other existing co-owners still in there, they would remain joint tenants with each other. Owners can partition the property. They have the right to partition. And it is possible to be converted to a tenancy in common or tenancy in severalty if somebody does destroy or break that joint tenancy by selling their interests. So let's give an example. Okay, I have video definition of this because I should have put a video here already. So let me just make a little marker and a note for myself to put the video explanation of the joint tenancy here on this slide. So let me take note of the slide number. So this is chapter 7, slide 14. Tenancy. All right. So this is the video. We're going to make one right now. Joint tenancy. If you have three owners that have equal ownership shares, owner A, B, and C, what type of ownership is this? If you simply look at the diagram and see three owners with equal ownership shares, you can't tell. I would say, without any further information, it's tenancy in common. Because you have to specify you wish to take ownership as a joint tenant. So if we don't have any additional information, I'm going to tell you tenancy in common. Now, if I told you that if one of the owners die, the other two owners split their shares, now I know it's joint tenancy. Or if I ask a question, I say, can each owner leave their shares in a will to somebody? And if they can, it's joint tenancy and not tenancy in common. Joint tenancy, you cannot leave your shares in a will if you die, because upon your death, the other survivors, co-owners, will automatically equally split the shares of the owner who died. All right, so owners A, B, and C have equal ownership shares. Owner B dies. What happens? Owners A and C automatically split their shares equally, and each one of them is now 50-50 owner. This is the right of survivorship. When one co-owner dies, the surviving owner or owners will automatically equally split the shares of the owner who had died. If there was only one owner left, well, they would now own in severalty. And now, if you're an owner in severalty, you can leave your shares in a will to whoever you want. There's no more right of survivorship at that point. Now, let's see. So now we have owners A and C, 50-50 owners. Owner C dies. What happens now? Owner A owns as a tenant in severalty because they're the last owner. And severalty comes from the root word sever. You're the only owner, the sole owner so now you can leave your property in a will to somebody if you wish. Okay. Everybody understand that concept of joint tenancy? Of with the right of survivorship, how that works?
Yeah.
Okay. If you ever need to, I got these slides you have access to, and I have these definitions written up here. And I also have the explanations or in the videos you can watch. All right, now let's give another scenario. We have three owners, A, B, and C, all own as joint tenants. Now, owner C is sick and tired of A and B's crap and wants out. So what he does, he sells his interest to this new guy, D. Now, D does not have the four unities in common as A and B and C had together. C sold their interest to D, and they transferred that interest using a different deed. And D got their ownership at a different time as A and B. So they do not, they're missing the unities of time and title. They still have the same common interest and possession, but they don't have the four unities. So D, therefore, now is a TC, that's a tenant in common with A and B. However, A and B still remain as joint tenants with each other. You following so far?
Yeah.
Mhm.
So D, at any time, if they die, they can leave their interests in a will to their heirs. A and B still cannot because they're joint tenants with each other. They're tenants in common with D, but they're joint tenants with each other. So now if B dies, what does that do to the joint tenancy? The joint tenancy is no more. So now it's just a tenancy in common between A and D. And A has a lot more ownership now. So both parties can leave their shares in a will to their heirs if they wish at this point. Go ahead, ask me. Why would you do this? Why would somebody create a joint tenancy? Why would they want to do that? Go ahead, somebody ask.
Why would they do that?
Ask a lawyer. This is the way I'm going to avoid liability. Remember, we're not attorneys. We don't give legal advice. So you should talk to an attorney if you have concerns about why somebody would want to do this. You know, I mean, I would guess maybe for a business interest, if they bought a property together to run a business, they're all friends, you know. And so if one of them dies, the business goes on. Some relatives aren't just going to inherit it and then want to sell it off and then force them to go out of business. Maybe that was the plan. I don't know. Talk to an attorney to see if that would be a viable option or if there's a better option to do that with. I don't know. But that's what it would sound. That sounds like a good reason to me. All right, now, so this is how joint tenancy would work and how you can destroy a joint tenancy and then just be left with a tenancy in common. Next up, we have a tenancy by the entirety. So a tenancy by the entirety is a special tenancy between, I want you to cross out husband and wife. Oh, actually, they don't even have that written in this version of the book anymore. Right now, they changed it to between spouses. You can write married couples above that. Because if you guys recall, Governor Christie signed gay marriage into law here in New Jersey when he was the governor. So a tenancy by the entirety is a special tenancy between spouses, married couples, husband and wife. This is the way that, well, actually, it used to be husband and wife. Married couples can now be man and man, woman and woman, you know. So between spouses or married couples. All right. And so this doesn't say husband and wife here anymore either. So let me see if I got some screenshots so I could swap out that with an actual screenshot from this version of the book. Let me see if I got the screenshot somewhere here. Here in chapter 7. Tenancy, oop. Between spouses. Okay, I got it. So, delete this from the slide. And there we go. This is the screenshot from this version of the book. Okay, all better.
Got it.
Let's see, let's read what they have here. So basically, the owners must be spouses when they receive the property. The owners have the right of survivorship, just like joint tenants do. You know, when one spouse dies, the surviving spouse inherits the property. They get the ownership. At least for the primary marital residence, they do. Remember, if you're married after May 28th, 1980, no more dower and courtesy rights. So therefore, only the primary marital residence your spouse has an interest in after May 28, 1980. And you can have ownership of other properties on your own or with other people. Let's see, there's no right to partition. Yeah, I think your relationship is suffering from other issues if you're looking to sue your spouse to force them to move. I don't want this house no more. I'm going to take you to court and sue you and force you to sell it. Yeah, that's not a good move for married couples, is it? So married couples do not have the right to partition. In New Jersey, a conveyance to a couple who are legally married to each other or registered domestic partners or members in a civil union in New Jersey creates a tenancy by the entirety unless the deed expressly states otherwise. In New Jersey, couples 62 years of age or older can register for a domestic partnership if they meet certain requirements. When a couple gets divorced, the tenancy by the entirety is broken and they become tenants in common. New Jersey does not recognize common law marriages either. And under New Jersey law, a couple in a civil union are entitled to the same rights as married couples are. Just get married. All right. So basically, I got the same stuff written here in my slide. Ownership by married couples, tenancy by the entirety, primary marital residence only if you're married after May 28, 1980, or to all properties that you own if you were married before May 28, 1980, because you got dower and courtesy, but then it doesn't apply to gay marriage because gay marriage didn't exist back in 1980. Governor Christie only passed that into law just a couple of years back when he was governor. Owners do have the right of survivorship. So if your spouse dies, the other gets the primary marital residence. They can't leave it in a will to someone else to get, and then they kick you out. You know, it doesn't work like that. New Jersey does not have common law marriage, never has, but some states do. What is common law marriage, you may be asking? Well, common law marriage means that if you're living together for a long enough period of time as a couple, and you're living together, and most people recognize you as a couple, you can be recognized as a married couple if you wish. Now, there would be different periods of time, how long you'd have to be living together for it to be considered a common law marriage depending on which state you're in. Once again, New Jersey never had common law marriage, so it's not an issue. So here, I click on that link, takes you here, and let's see, the states in green you could see have common law marriage, states in red do not. There's a better way to look at this as of 2024 in the United States. you may be familiar with the term common law marriage, but a lot of people misinterpret it as meaning that if you're living with someone else for a period of time, you're automatically husband and wife, or married, you're a married couple automatically. No, you would have to be a couple living together, and you'd want to be considered a married couple. You know, especially now with gay marriage, that could really make things screwy. You know, if you had a roommate for years that you've been living with, you're automatically considered married if you live together. Whoa, whoa, whoa. So, yeah, you'd have to also be a couple and want to be considered and recognized as a married couple. So states with common law marriage, 8 states acknowledge, let me see, states with common law marriage. Before we get into specifics surrounding common law marriage, let's identify which states acknowledge those relationships. There's 8 of them as of 2018. Colorado, Washington, D.C., Iowa, Kansas, Montana, New Hampshire, Texas, and Utah. Let's see. In Washington, D.C., marriage is legally recognized without a ceremony or marriage license if both parties are legally going on. Just lost my mouse. Sorry.
Okay.
I had it plugged in all night. And let's see. Let me try to get this thing finished up again. I have it plugged into the right cable. Battery dead. That would suck. Sorry about that.
No problem.
Hold the phone for one moment while I get things together. Yeah. Oh. So that's why the mouse wasn't charging. We got it all settled up. Okay, so let's see. So states with the common law marriage, New Jersey was not one of them. And then some states, even if you got common law marriage, other states may possibly recognize the common law marriage from another state. Here are some states that previously allowed common law marriage, as Alabama, but they got rid of it in 2017. Florida got rid of it in 1968. Georgia, they got rid of it in 97. Indiana, 58. Ohio got rid of it in 91. Pennsylvania got rid of it in 2005. And South Carolina just got rid of it in 2019. Wow. So states, there's not many states that do recognize common law marriage. These are the only ones that do, with the green check box here. And New Jersey ain't one of them. So there you go. That's all you got to worry about. All right. Now, when a couple divorces, ownership reverts to a tenancy in common, which is the default form of ownership with 2 or more parties not married to each other, and they no longer have the right of survivorship if they are getting divorced. So therefore, then they do have the right to partition the property. You could sue your former spouse, forcing them to sell or divide the property. And that's usually what happens during divorces. Now, you can't force your spouse to sell the property while you're still married, but once you get divorced, then and only then can you force them to sell the property, to partition it. So there's no right to partition while you're still married, only after divorce. And a corporation cannot be a tenant by the entirety because corporations don't get married. People do. When corporations get together, they're called mergers. And when they fall apart, they need to be dissolved. Okay, so married couples do have the right of survivorship. They do not have the right to partition until they and if they divorce. All right, so just a rundown again. Tenancy and severalty is ownership by one person or entity. Tenancy by the entirety is ownership by married couples. Tenancy in common, or TIC, is default form of ownership by more than one person or entity. That may have they could share partial ownership interest in shares. Joint tenancy, you have to specify you want to take ownership this way. Corporations can never own as joint tenants. They must have 4 unities in common to have a joint tenancy, TTIP, time, title, interest, and possession. And the only benefit is the right of survivorship, which, by the way, tenants in the entirety also have. So real estate licensees should never advise someone as to what form of ownership to take, because that would constitute legal advice, and we're not attorneys. We do, however, need to be aware of the different forms of ownership. So if you want to snap a picture of this one, which just gives you a basic rundown of them without going through all the details, like tenancy in common, you can leave your shares in a will to heirs. Joint tenancy, you cannot. Things of that nature. Now let's talk about different types of business structures. Business ownership of a business, not ownership of real estate, but ownership of businesses. Sole proprietorship means that there is one owner. Partnerships are usually consist of 2 or more owners together, and there's different forms of partnerships. We have limited partnerships and general partnerships. We're going to get into those. Corporations are legally formed business entities. Limited liability company, and LLC, does not stand for limited liability corporation. It stands for limited liability company. It gives certain legal protections and tax benefits to the owner operators with less paperwork than a corporation and less expense. If an LLC is starting to make a lot of money, though, they could get additional benefits and tax purposes if they file as an optional S corp. Syndicates and joint ventures are not legally formed business entities. They're just the joining together of 2 or more people or 2 or more entities for business to carry out a business project. When that business project is done, the entity's done. And real estate investment trust REITs, we're going to get into those and who tax benefits as. So, that being said, partnerships. So let's do the highlights here, if you can.
I think the screenshot is a little different. There's more.
Is it? Let me take a look. I'll see what I got here in the screenshots. I may have something separate pertaining to partnerships. Let's see. I do have an updated one. Let me get to the slideshow and I'll replace that screenshot. So let me delete the old one. And this is the new one. Also fits. Ooh. A lot of highlights here. Better?
Yeah,
But-
got it.
So this is page 123. So there's generally two forms of partnerships. Both forms of partnerships always have at least one general partner. So, who the hell wrote this new version of a book up? Look at this guy. Whoever made these modifications to his latest version of a book, look at this. They wrote, ironically, there's no general partner in a general partnership because all the partners participate in the day-to-day management of the business venture. No. In a general partnership, they're all general partners. So that statement is completely wrong. All forms of partnerships have at least one general partner. In a general partnership, all the co-owners are general partners. We just write the page number. Page 123. So in a general partnership, all the co-owners are general partners. A general partner is someone who works the day-to-day activities of the business, and therefore they can be held liable for any additional debts that the business takes on. You take out an additional loan, the general partners can be held liable to pay it back, not the limited partners. So let's see what they have here. In a general partnership, all partners participate to some extent in the operation of the management of the business and may be held personally liable for business losses and obligations, even beyond the amount of their initial investment. In a limited partnership, includes a general partner as well as a limited partners. The business is run by the general partner or partners who work the day-to-day activities of the business. The limited partners do not participate in the operation of the business, and each can be held liable for the business losses only to the extent of their investment in the property or in the business. See, the limited partnership is a popular method of organizing investors in real estate. Okay, so, And this statement down here is completely wrong again, because limited partnerships must have at least one general partner to run the business. The general partnership is the one that does not have a general partner. No, that is not true. General partners, in a general partnership, all of the co-owners are general partners because they all can be held liable for any additional debts the business takes on because they all work the day-to-day activities of the business. In a limited partnership, only at least one of the co-owners has to be a general partner that's responsible for the business, that works in the day-to-day activities of the business. All the others are not. And let me give you a good example of a limited partnership business. You want to start a business. So you go and you get a loan from the Bank of Mom, right? Mom don't care about your business. She just hopes that you're successful in all your endeavors, right? Now, because Mom is an investor in your business, she's now a co-owner in your business. But Mom doesn't know anything about your business. She's not working the day-to-day activities in your business. She's a limited partner. You, however, are a general partner because you are the one that works the day-to-day activities of the business. If you go out and take additional loans for that business, Mom is not responsible for paying them back. You, however, as the general partner, would be. The only thing that Mom is risking is her initial investment. She could only lose her initial investment in the business. she can't be held liable for taking out any additional loans that that business has taken out. Understand?
Yes.
Whoever did this rewrite here in the book is absolutely wrong. I don't know why they're giving these people the ability to do these rewrites. I I just thank God that I did not involve myself. I was supposed to be involved in this rewrite, but whoever did the rewrite changed a lot and they screwed up a lot too. So I'm just going to put a line through this, because this stuff is completely wrong.
I was gonna say maybe you should have been involved in it. They would have got it right.
Yeah, but you know what? They only wanted to pay me $500 for it,
What?
and I
Oh,
had to keep my mouth shut for so many years that I was involved in it, and I basically couldn't take credit, and any language or wording that I used, I wouldn't be able to use anywhere else. And I was like, no, I'm working on writing my own book again. I previously did, and then I lost it when I lost the hard drive on my computer without a backup. So I was planning on doing a rewriting my book again. And so I'm not going to do that, especially for only $500. Get the hell out of here. And then give up my rights to some of the explanations that I give. I would have shared them with you in the books and you could pay me, but I'm not giving up my rights to my own intellectual property, especially for $500. Thank you.
right.
You
That's
know,
ridiculous.
so that's where I told them to go pound salt. All right, so these things are wrong. So let's just cross them out. Because this stuff is wrong. Let's see. Insert. All right, so I just wrote that there. Okay, so we crossed out the wrong explanations. There we go. Good enough. All right. So what do you need to know? All partnerships have at least one general partner. General partnerships consist of all general partners. Um, and limited partnerships have at least one. Includes a general partner as well as limited partners. So here, let's see if we could even tweak this out a little bit more here. Let me cross this out. Page 123. I'll get rid of that. We'll put this up. Let's see. All partnerships have at least one general partner. Who is responsible for any additional debts the business takes on. And a general partnership, all the partners are general partners in a limited partnership. There is at least one general partner. Good enough. Good enough. Now, I have that definition here on the next slide. General partnership, all co-owners are general partners. A general partner is an owner that works the day-to-day activities of the business and can be held liable for any additional debts the business takes on. And a limited partnership has at least one general partner and the rest are limited. They're limited in their liability. They do not take part in the day-to-day activities of the business, and therefore they're limited in their liability to the extent they cannot be held liable to repay additional debts the business takes on. They can only lose their initial investment in the business, like I explained with getting the loan from the Bank of Mom, right? That's basically how a limited partnership works. Mom would be a limited partner in that regard. So the worst that could happen is she could lose her initial investment in your business. That's it. Real estate ownership by corporations. A corporation is an artificial person. They're a fictitious entity for taxation purposes. And a corporation's artificial person, fictitious entity for taxation purposes and legal protections. Corporation, because they separate you from your legal liabilities so that people can't touch your personal belongings like your house. If you have problems with your business, they could sue the business for its money and its assets, but they can't touch the owners of the business. Corporation separates you from your business as an individual. Now, an LLC, even though that's not a corporation, it's a limited liability company, it offers the same types of protections too, also with a little bit less paperwork. So corporations require a lot of paperwork. You got to have a lot of people in different positions, and you got to file reports. You got to have meetings, and it's kind of costly to maintain a corporation. It costs a lot more money you got to lay out just to have a corporation each year. LLCs, it's not as much. So corporations cannot own real estate as joint tenants or tenants by the entirety because their life is perpetual. It lives on forever until it's formally dissolved. It would always be the last man standing, so to speak. So a corporation can't be a tenant by the entirety because corporations don't get married, people do. When corporations join together, they call that a merger. So, corporations can only own real estate as tenant in severalty if it's sole ownership, or tenants in common if a partial ownership interest. Where a corporation can own a property with an individual or with another corporation. Corporations are managed by a board of directors. They make all the major decisions to buy or sell real estate. They look out for the best interest of their stock shareholders, or at least they should be. In recent years, we've seen a lot of these protests, which are more like violent outbursts from kids who are on some social justice mission. They think it's okay to start robbing individual store owners and stuff in the name of social justice. Yeah, that's dumb. You burn down your neighborhoods and you chase out the businesses from your own neighborhoods. That's a pretty stupid thing to do. Well, look out. So the board of directors, in recent years you're seeing some CEOs or maybe even board of directors in some instances, they caved into the pressures of some of these groups, who threatened um, to give them bad publicity, uh, if they didn't cave in and donate money to their causes and publicly support them, you know. So I mean, we were seeing this with a lot of groups, like the BLM groups, you know. Hey, Black Lives Matter, of course they do. That should go without saying. But this is just a group that was created to just co-opt the name that everybody's on board with. However, this is a group that was created by a couple of people who put the money in their own pockets and went on spending sprees, buying themselves mansions and expensive cars and stuff like that. It's amazing that the group is still together. Even though the original creators of it on a national level are in jail for their theft and money laundering and things that they've done. I just seen the head of one on the other day on the news with the Daniel Penny trial, um, calling for violence because a jury let somebody off, and he's saying, well, if you're for white people, you're with the KKK, which is pretty stupid. I mean, it's an individual case on a case by case basis. You don't judge people as a group; you judge them as individuals. Anyway, these corporations, a lot of them, everything from the BLM stuff to the what are these other movements where the gender, all that weird gender stuff that's going on right now, that you could create your own gender identity and stuff like that. These movements, well, now as that angered a lot of people who are like, that's ridiculous. This is nonsense. We're not buying your stuff no more. So a lot of people's stock values have dropped, and it's because of the decisions that the CEOs or board of directors have made, where they were supposed to be looking out for their shareholders' interest. Instead, they decided they wanted to get involved in social stuff. Listen, if you're a celebrity or if you're a CEO of a corporation, sell me your product, sell me your service, sell me your music or your art. Don't go preaching to me about social stuff. I'll make my own decision on those things. And so people get outraged, and all you're going to do is shoot yourself in the foot when it comes to your support for your art or your business. It's a dumb business decision to make, and by hopping on board of these things. I mean, I don't know about you guys, but if I'm going to support somebody because I like their music, I'm going to buy them because I like their music. I don't want you preaching to me about your politics. That's that's kind of ridiculous. People who, but the only people you're going to get following like that are either immature, ignorant, or they're little children. That do that kind of stuff. Like the Swifties, they follow her everywhere. They do whatever she says. But I mean, who's listening to her? I don't take my legal advice or my political advice from Taylor Swift. But some of these corporations actually did that kind of stuff, and so it's amazing to me that more lawsuits have not popped up yet by shareholders who have lost a lot of money. Just take, for instance, Bud Light. Look how much money they lost their shareholders when they took on the that trans guy that was, having commercials to sell Bud Light. It's like, listen, the majority of the people that drink in Bud Light are probably not supporters of that kind of a movement. So you're shooting yourself in the foot naturally, and it was obvious when that company lost billions of dollars because of one president of a division of marketing for Bud Light, and that company's still trying to recover from this. It's amazing the shareholders have not sued the company relentlessly, or at least not publicly that I'm aware of. for their decisions, which cost them a lot of money from buying stock to invest in your company. So these shareholders, the board of directors, they're supposed to be looking out for the best interest of their shareholders. And a corporation can convey real estate only upon a proper resolution passed by its board of directors, because they're supposed to be looking out for the best interest of all of their shareholders. And anytime a major financial decision is being made, like to sell a lot of their real estate or to make large real estate acquisitions, they need to run that by the board of directors. The president or CEO can't just do that on their own, because the board of directors have a more focused goal. This president or CEO is supposed to be looking out for the company, but the board of directors, they have a direct interest in looking out for the shareholders' best interest. Okay, so on page 366, there's some stuff that we're going to need to highlight there. Is this on page 366? No, this is on page 124 at the top of the page. And I guess it's not 366, it's 364. Wait, hold on a second. It's not 366. Don't write 364 there. I think it's supposed to be 366. Let's see. Yeah. So I got another screenshot to change right here on the slide. Just put where that page number is, right? 366 instead of 364, but it's the same highlight.
Got it.
As you can see, just a different page number. And then we're going to go to page 366, and we're going to highlight this on page 366. The corporation can convey real estate only upon a proper resolution passed by its board of directors. That's probably going to be an exam question. So if all or a substantial portion of the corporation's real estate is being conveyed, it is also usually required that a resolution authorizing the sale be secured from stockholders. Now, deeds to real estate can be signed only by an authorized officer. So this is pertaining to us. If we have somebody comes to us, they want to sell a house or some kind of commercial real estate or what have you, and we see that the ownership is in the name of a corporation, and we have an individual coming to us. We need to make sure that that individual has been authorized by the corporation to sell the property. I mean, what gives you the right? Are you even affiliated to this corporation? So we're going to need some kind of documentation. So if somebody lists a property for sale with us on behalf of a corporation, we need to make sure that they're the actual owner of the corporation, or they're somebody who is assigned by the corporation, given the authority to act on the corporation's behalf to sell that property. And usually, a corporation will assign an authorized officer to handle this. So the authority of the officer must be granted by a resolution properly passed by the board of directors, putting that person in charge. And then it says, note that the corporate seal need not be affixed to the conveyance unless there's an acknowledgement that mentions the seal, the corporate seal. So, but we will need a document that says that this person is authorized to sign documents on behalf of the corporation in the sale of the real estate. Otherwise, don't go taking that listing until you get it. Okay. Everybody got butt?
Yes.
All right. Then you could go back to page 124. All right, everybody back on 124.
Yes.
I'm gonna update something here. Let me make sure I got the right page numbers. I'm gonna be showing some more cross references here. Yes, I got some. Okay. Okay, so back on page 124, syndicate is a joining together of two or more people to carry out a business project. They're not a legally formed business entity. They're just two or more people that come out, together to carry out a business project. Like if you and I buy a house together so that we could fix it and flip it, we created a syndicate. Two or more people come together to create a business project. When the business project is done, we fix it, we flip it, we sell it, the syndicate's done. Okay. Now, in a similar manner, so you don't have to file any paperwork or register with the state to create a syndicate. Okay. It's just a joining of two or more people to carry out a business project. In a similar fashion, a joint venture is a joining together instead of two or more people, it's a joining together of two or more groups to carry out a business project. So once again, it's not a legally formed business entity, just like a syndicate isn't. And when a project is done, the joint venture is done. Seek legal advice about any business entity creation. REITs. A form of organization that's useful for taking advantage of certain tax benefits would be a REIT. Who says you need to invest in mutual funds for your retirement? Why not invest in something that puts the money in real estate? Like a REIT would buy large commercial properties, office buildings, apartment complexes with hundreds of units. You can be sure that they'll be profitable, right? If you own an apartment complex, it's profitable. You got hundreds of people paying rent. Sure, you get a deadbeat every now and then, or people don't pay their rent, and then you got to deal with getting them out and all that stuff. But overall, the project, the apartment complex is profitable, right? So the a real estate investment trust is a type of trust that invests instead of in commodities and stocks and bonds, they invest in real estate as the investment vehicle. That's what a REIT is. Sometimes you may have somebody who's running a REIT reach out to you and ask if you have any certain projects that meet their profiles. I've had them come to me before. They were looking for a project to see if I had any listings or if I knew somebody that was looking to sell a large apartment complex. But they were looking for large purchases, things of a minimum of $10 million purchases. So if they're coming to you, you're looking at a large deal. So they get the same tax benefits as mutual fund investors, but they must have at least 100 investors to have a REIT, and at least 75% of that trust income must come from real estate as the investment vehicle. They're a stable investment that pays out slowly. The only time they'll pay out big is if they go to sell that property at some time in the future, which usually they don't. They hold on to it for a long run, long-term investment. They buy large apartment complexes with several hundred units, high-rise buildings, business centers, shopping centers, malls, things of that nature that they invest in. But what do you need to know for exams? You need to know, who do REIT investors get the same tax advantages as? Mutual fund investors. I don't know why, but it's an exam question, at least sooner than later, hint, hint. So let's do some highlighting on page 124 under other forms of ownership. A real estate investment trust REIT is a form of organization that's useful in taking certain advantage of certain tax benefits. They get the same tax benefits as mutual fund investors. You write that down on this page underneath that with a cross-reference saying see page 333. And then after you do that, go to page 333, and this is a screenshot from 333, where you're going to highlight real estate investment trust REITs. Real estate investors can take advantage of the same tax benefits as mutual fund investors. And let me know when you got all that, okay?
Okay.
I'm good.
Yeah, okay, you got the highlights on 333 as well?
Yep.
Everybody else got it too?
1 second.
Okay.
Okay.
All right. Condominiums. All right. Let me make sure that I got the latest screenshots on these things. I know I got some screenshots here, so let me just make sure I got the latest here for the condo stuff. Okay. Well, I have no additional screenshots, so I'll assume that this is the same stuff. And it looks like it is. It's just that on the newer version book, it's split. The section on condos and co-ops, this is split between page 124 and 125. I think 125 starts this next paragraph right here. Yes, it does. So let me just make that marker on the slide. Over here, this is on page 125. All right, so condominium and cooperative ownership of housing has risen in the second half of the 20th century, together with townhouses, planned unit developments, condos, and co-ops. They offer the emotional, financial, and tax advantages, just like homeownership, combined with the various advantages of apartment living. As opposed to traditional single-family homes, condos and co-ops offer more efficient use of ever scarcer building land, lower costs for lot development, less outlay for construction per living unit, and some savings in maintenance and heating bills. Contributing to the growth of condos and co-ops are changes in population patterns, with us having an increase in numbers of single-family homeowners, one-parent families, and senior citizens. You know, as the times change and, as the times change and the structures of families, I guess, have changed, and just societal changes. Um, these things may contribute to the growth explosion of condominiums and co-ops. Um, to such groups, community living offers security, sociability, ease of maintenance, and sometimes the opportunity for sharing expensive recreational facilities like swimming pools, exercise rooms, boardrooms, banquet halls, IMAX movie theaters, things of this nature that you could often find in these uh, condo and co-op complexes. The term condominium and cooperative refer to the forms of ownership, and looking at a shared housing complex gives no clue as to whether it is a condo, a co-op, or in some cases a PUD, the planned unit developments. The buildings themselves may be high rises, they could be townhouses, patio homes, garden apartments, or even single detached houses. So they could be of different architectural style, basically. The legal differences arise from the differences arise from the legal forms of ownership. Condominium ownership is not limited to residential dwellings either. We have commercial condos. You guys ever go to a dentist, a doctor, an attorney, a chiropractor, somebody, a tax preparer, somebody who has an office in a condo complex, in a commercial condo complex?
Think so. I think so.
They're around. They're around. It's cheaper than them buying buying a single standalone commercial office building, you know? It makes it more affordable for that to happen. All right, now these are screenshots from a previous version book, but it's all the same stuff right here broken down. This is all on one page here, on page 125. I'll take another screenshot and update it. But let's see, cooperative ownership. Cooperative ownership is common in New York City. It's also found in some areas of New Jersey. We got some co-ops here in Edison area. Cooperative ownership became popular in the 1920s as the urban population grew after World War I. Individual housing became more expensive, and the board of directors were choosy about who could buy in. That doesn't mean that they were discriminating. However, I could see how easily it could be interpreted as you feeling like you're being discriminated against. I mean, this is not to say that discrimination never occurs anywhere. This is just saying that with co-ops, they can be choosy about who they select to live in their complex and or building, and it could really easily give you the impression, the feeling that you've been discriminated against. So I'll show you what I mean in a moment. So the number of newly built cooperatives have greatly decreased over the last 50 years. Under the usual cooperative arrangement, title to the land and the building is held by a corporation. Each purchaser of an apartment in the building receives stock in the corporation, and a fancy name for a custom lease is a proprietary lease that they get, which gives the purchaser the right to occupy the apartment that they're living in. The cooperative building's real estate taxes are assessed against the corporation as the owner. There's usually one underlying mortgage on the entire parcel of real estate. Taxes, mortgage, principal, and interest, and the operating and maintenance expense of the property are shared by the tenant shareholders in the form of the monthly maintenance fees or maintenance charges. So even though co-op owners do not actually own real estate, they own stock, which is personal property. The shareholders have let me see, accumulation. They do not actually own real estate. So let's even underline that. that co-op owners do not actually own real estate. Let's just not just highlight that. Let's also underline co-op owners do not actually own real estate. They own stock, which is personal property. So for all practical purposes, they do control the property, though, through their stock ownership and their voice in the management of the corporation. Co-op bylaws generally provide that each prospective owner must be approved by the board of directors. And they often do have minimum credit score requirements. It is not uncommon for them to have, say, a 620 minimum credit score requirement. That's kind of different than a condominium. If you go to buy a condominium, as long as you have the money or you get a loan to purchase it, the homeowners association don't care what your credit score is. You don't need to get interviewed and approved to move in there. However, in co-ops, they do go through an interview process. You do have to fill out an application. They do have minimum credit score requirements. Why is that? Well, the credit score requirements, well, if enough people are not paying their monthly maintenance charges, which actually go and get contributed towards the property taxes and maybe an underlying mortgage for the entire property, as well as, paying for the maintenance of stuff, the corporation may not be getting in enough money to pay their important bills, and the entire complex could get foreclosed on. So because of that possibility, they have these minimum credit score requirements. They go through an interview process to make sure you're a stable person to the best of their ability, so that they can look out for the other tenant shareholders that live there in the complex. Now, sometimes some of these board of directors get a little out of hand on how they interview people. Sometimes here, let me just say it outright, they're snobs. These things are common in New York City, but they could also be here in New Jersey, right over there across the water from New York City and New Jersey, those areas, they have a lot of co-ops, not just condos. We even got co-ops here in Edison. And sometimes, let's say probably in New York City, maybe in, I'm trying to remember the town in New Jersey, across from the water there, Hoboken areas, or places like in California, where they have co-ops. They could be kind of snooty, where they could be like, let me give an example. They have an artist community in this building. This community is for artists only that live in this building. So you have to be some sort of an artist, whether it's a musician, a painter, an actor, a singer. You have to be some sort of an artist, and they're going to interview you to see what your art is, to see if you'll fit in with our community to live here. Sounds kind of snobbish, doesn't it? Let me ask you a question, though. If they turn you down, they deny you because you're not an artist. Is being an artist or not a protected class under the housing laws?
I don't think so.
Nope, it is not. So they could legally do that. They could turn you down because you're not an artist. You see how easy that could... You're going to turn me down from a place to live because I'm not an artist? What kind of bullshit is that, right? It's easily to get offended and to feel discriminated against because you were not allowed to buy in and rent there because you're not an artist. It's easy that some people feel like they're discriminated against. So there's a lot of lawsuits that come against these places for discrimination all the time because of stuff like that, nonsense like that. And in reality, it's not because you're being discriminated against. Normally, it's because probably your credit score, or they don't feel that you're stable or what have you. Or in some cases, in these snooty places, because you're not an artist. and it feels more like discrimination in those cases because it's not your financial ability to pay or your credit history, but you're being turned down still. But being an artist or not is not a protected class. So in that case, you could see how, even though it could feel bad, they're not violating the law because being an artist or not is not a protected class. Now, one disadvantage of cooperative ownership is the possibility that if enough owner occupants become financially unable to make prompt payments of their monthly assessments, the corporation may be forced to allow mortgage and tax payments to go unpaid. And that was actually a problem way back in the 1930s. Through such defaults, the entire property could be ordered sold by a court order in a foreclosure suit. This is why they do that interview process and have the minimum credit score requirements. So, such as a sale might destroy the interest of all the owners. So even though you were paying your monthly maintenance charges and such, your that HOA fee there in a co-op, if enough other of your neighbors are not, it could put all the neighbors there that live in that complex or building in danger. Unlike with condos, an individual unit can get foreclosed on, not the whole entire complex. So such a sale may destroy the interest of all owners, even those who paid their assessments. Accumulation of substantial fund of reserves for future repairs and emergency payments offers some protection to the cooperative as a whole. But usually with cooperatives, before they let it get to this point, what they're going to do is they're going to jack up the maintenance charge on people, and your neighbors who are paying are going to pay more to try to make up the difference. But that can only happen for so long. Okay, so highlight accumulation of substantial funds of reserves for future repairs and emergency payments. That's a definition of reserves. Add that term to your definition list. What are reserves? It's an amount of substantial funds accumulated for future repairs and emergencies. Now, cooperative shareholders have all the income tax advantages of the owner of a single-family detached house. The portion of the maintenance charge attributed to the property taxes and the mortgage interest may be taken as income tax deductions. Interest paid to finance the stock purchase is also deductible. Many co-ops do not permit rentals. Because, let me ask you a question. Who takes better care of a property? Renter tenants or owner occupants?
Their occupants.
Yeah, an owner is always going to take much better care of a property because it's theirs. They have pride in it. They take better care of it rather than a tenant who got the attitude, I don't give a shit. It ain't my property, right? Let the landlord deal with it, So if you have a ratio too high of too many renters there, a prospective buyer may have difficulty obtaining adequate financing. Oh, which brings something up, by the way. How do you buy a co-op? You have to either have the cash or you get a personal loan. You do not get a mortgage loan. Why don't you get a mortgage loan to buy a co-op? Well, let me ask you a question. What's a mortgage?
Promise to pay back.
It's a promise to pay. And what is that promise saying? The promise says, lender, lend me your money, and I promise to pay you back according to the terms in the note. The note is the financial instrument that basically says that it's what holds you personally liable for the money you borrow. It states out how much you borrowed, what your monthly payment's going to be, what the interest rate is, and all that stuff. And it says that in the event I don't pay you back according to these terms that I'm agreeing to, you can foreclose on me and take ownership of the property. Hold the phone. What do you own when you own a co-op?
Equals stock in the corporation?
There you go. Each purchaser of an apartment in the building receives stock in a corporation and a proprietary lease, which gives the purchaser a right to occupy their apartment. However, you do not own real estate. Co-op owners do not actually own real estate. They own stock, which is personal property. So how could you make that promise to pay? You can't. So this is why you do not get a mortgage loan to buy real estate, to buy a co-op, because you don't own real estate when you buy a co-op. So you can't pledge that property as security for the loan because you don't own it. You own stock. So it's a little bit different. You can get a personal loan to buy a co-op, but not a mortgage loan. That's the difference there. Technical difference, but nonetheless, it's a difference that you should understand. Now, New Jersey law provides that owners of co-ops in buildings with 10 or more units may rent their units if they've been trying to sell for 4 or more months at a price no greater than their initial investment to purchase it. If that's the case, then you can rent it. Otherwise, most co-ops do not permit rentals. Now, cooperative living tends to develop somewhat differently from condominium occupancy. Long-term stability of tenants is common. The corporation's right to accept or reject any new owners aimed at safeguarding the present owners, who would share the financial responsibility for a defaulting neighbor who's not paying their monthly maintenance charge, which goes towards the taxes and insurance, taxes and possibly the underlying mortgage of the property and insurance, etc. But it's often used to maintain a particular level of occupancy as well. So co-op living is a lot more stable, though. The property values don't fluctuate as much as condominiums do. And co-ops are much cheaper. For example, in Edison, if you were to take a look at how much it costs for a 2-bedroom, 2-bath condo, let's just say you're getting one for $300,000. That same 2-bedroom, 2-bath condo in the same type of complex that has all the same features, the tennis courts, the swimming pools, all that stuff. If it was a co-op in Edison, you could probably get that for $65,000 to $75,000. Wow, I'll just buy a bunch of them and rent the others out. No, you won't. Because most co-ops don't allow rentals, right? So this is why investors aren't going to be going in there buying, because then if they run on hard times, they're just not going to make the monthly maintenance charges, and the whole complex could end up getting foreclosed because they don't care. So this is why they don't allow those rentals and the purchaser of people who are not owner occupants. But you could still have ownership of a property. No, your guests won't know if it's a condo or a co-op. It looks the same. It's got all the same features. It doesn't seem like there's any difference between a condo and a co-op physically. The differences lie in the form of ownership. That's it. Now, in a cooperative ownership, title to the land is held by the corporation as the owner. So purchasers do not own real estate. They own stock, which is an intangible personal asset. They get a proprietary lease. That's a fancy name for a custom lease, in which gives the tenant shareholder their right to occupy the unit they're living in. Income tax advantages are identical to those of single-family homeowners. Tenant has a voice to control the property management through their stock ownership. Maintenance fee is usually much higher than condos because it includes the underlying mortgage on the property, the taxes, insurance, and those CAM charges, which is short for common area maintenance charge, for the dumpster, the sewer, the water, the heat, trash, snow removal, maintenance of the pool, tennis courts, etc. The value of the property tends to be stable and does not fluctuate as radically as it would with the condo ownership. So co-ops are usually much cheaper than the condos because you're not owning real estate. However, the monthly maintenance fee is higher because with co-ops, you get your separate bills for your own property taxes and insurance and all that, where this may be all included in a monthly maintenance charge with the co-op. All right, so co-op ownership has a shared expense. There's usually one underlying mortgage for the entire property. There's tenant shareholders that share these expenses with their monthly fees that go towards the paying that mortgage and the property taxes, because individual tenants do not get a tax bill because they don't own real estate. The corporation that owns the entire complex does. And it's paid out of part of their monthly maintenance fee that all the tenants pay. Bylaws require each purchaser to be approved by their board of directors, which manage the corporation. There's usually a minimum FICO credit score requirement for that Fair Isaacs credit reporting system there of 620, because anything below 620 is considered subprime. 620 is prime, that's average. Most do not permit renting, and if there's one exception to the law that if there's at least 10 or more units and the owners tried renting their unit for at least 4 months or more at a price no greater than what they paid for it and they're unable to sell it, then they could rent it. Long-term stability of tenants is common, and financing of the purchase is going to be done with cash or a personal loan, not a mortgage loan because you don't own real estate. Real estate agents cannot prepare sales contracts for co-ops. Why? Because, well, it's not real estate. You're selling stock. So an attorney has to prepare the contract for selling a co-op. All right, page 126. Condominium ownership. Second paragraph there. Buyers of a condo receive a deed conveying fee simple ownership of two things: their living unit from the paint on the interior walls inward, and a proportionate undivided interest in the common area elements. Now, the first condominiums were built in Puerto Rico in 1958, and the FHA was allowed to insure mortgages for condos by 1969. Many people were introduced to condominium ownership in Florida, which had introduced the concept from Puerto Rico. Popularity stems from the ability to obtain affordable housing, often in highly desirable areas that would normally be typically beyond the economic reach of most. But when you have that shared ownership of the land and then all those units within it, it makes it more affordable. So chief among common elements for condos are the land itself, the exteriors of the building, and the common property could also include the hallways, basements, elevators, stairwells, driveways, private roads, sidewalks, lawns, landscaping, swimming pools, tennis courts, etc. These are the common area elements which all will hold a share of interest in. Now, in many respects, condo owners may be regarded in the same light as the owner of a single detached house. Title can be held in severalty or by the entirety, as joint tenants or as tenants in common, which we just learned about. The unit receives an individual tax bill and may be mortgaged just like a house would be. The owners place a separate insurance policy on their living space. Income tax advantages are identical to those for single-family homes. And the owners are free to sell the property, lease it, give it away, or leave it to their heirs. Each unit is a financial entity on its own, and if an adjoining unit is foreclosed, no obligations incurred by the other owners. It doesn't affect your neighbors. However, owners are, bound by the bylaws of the homeowners association. These are those rules and regulations they create, to which the homeowners association, everybody who owns a condo, a unit in the complex, will be a member of the homeowners association. That's what I say, to which all will belong. And as long as those rules that they create are not unreasonable, New Jersey law does permit associations to enforce their own rules by fining residents who fail to comply with them. It's kind of like a mini city within a city, right? It's like a government. Okay, so we have these elected leaders, just like politicians, right? Now, within the condo complex, you have these appointed leaders. You know, why do you buy in a condo? Why would you buy a condo in a condo complex? It's to get a place to live. It's not to join a mini government. However, a lot of them, you have homeowners association, and they appoint some of the homeowners to run the management. A lot of times that I've sold condos, it was people that were happy with where they lived, but they couldn't stand the management. You know, the power went to their head, just like with many politicians. You know, you get these people that they create these rules and they walk around like they're all power hungry, like their S don't stink, you know, and they create these rules. Now, all homeowners can go to these homeowner association meetings, but most don't. So they leave it to a few elected leaders that are appointed to the homeowners association, and they're sitting there making up rules, and sometimes they get a little wacky with them. Now, they says as long as rules are not unreasonable, but what is unreasonable? That could be questionable. What is reasonable? However, while condominium boards can stall or exercise the right of first refusal if it does, they rarely have the right to file to evict an owner. Monthly fees are levied for the maintenance, insurance, and management of common elements. If unpaid, these common charges become a lien against the individual unit and may even be enforced by foreclosure if you don't pay them. Bylaws also set up covenants, conditions, and restrictions known as CCNRs. Those CCNRs, the covenants, conditions, and restrictions, these are the legal restrictions that you agreed to abide by. Just like if you buy a single family detached house that's owned in fee simple ownership and not condominium, if you have a fee determinable estate, remember we learned about estates and land that are based on restrictions, those fee determinable conditional fee estates. If somebody puts a restriction in the deed, you have to obey it. You know, bylaws of the homeowners association, you have to agree to abide by them. Now, some people may have arguments about, well, what if it was something that was decades ago and the people who made these rules are no longer around? It works the same way with a single family house. You have to abide by the rules. And if that person's dead or they moved away, they're no longer around, you can't go around it by going to a judge and going to a court and asking a judge to ignore them. They're not going to. You agreed to these contractually, these agreements when you bought the place. And the only way around it is to get the person who put that agreement in place or those rules in place to dismiss them. If they're dead, you'd have to go to their heirs or whoever inherited their rights to try to get them to dismiss them if you'd like them dismissed or changed. So with condo associations, though, when they create bylaws, you got a homeowners association, HOA, that could make these changes from now on. They usually just make additions to it, but they could make changes. But they usually start off with a guideline, and some of those changes they cannot make changes to because it's the property owner who created the condo to begin with. Was the property owner, the original one, that made these rules. So, for example, they may prohibit displaying a for sale sign or painting a front door bright red. Can you do an open house at a condo? What would you think? Can you do open houses for condos?
No.
Well, you can, but it'll be kind of difficult because most of them don't allow you to put up for sale signs, let alone directional arrows with balloons on them during the weekend. You're going to have the maintenance driving around, pulling them out of the ground and throwing them in the back of their pickup to throw in a dumpster. They really need to be by appointment, because otherwise, how are they going to find out that you got an open house? Because you can't have these signs and balloons and directional arrows leading to, saying that there's an open house. So usually with an open house, it's by appointment only. So how different is that than just having a by appointment only selling a house? It's not. So you really generally don't do open houses for condos. A condominium is governed by a board of directors consisting of often elected volunteers who actually live in the building. As fiduciaries, they have a responsibility of loyalty and care and duty to protect the community as a whole. They should have enough time on their hands to be involved and possess the knowledge of accounting and good business practices to preserve and protect the assets, kind of like politicians that you elect as leaders in your town, your municipality. Hopefully, they're going to be working in your best interest and not their own self-serving interests. The day-to-day operations of condominiums are generally handled by a condominium manager. Yeah, we know politicians never get corrupted, right? So at this local level, there's little concepts, the little condo complex. Unfortunately, sometimes power goes to people's heads, and it becomes a stereotype. And you'll see that even in some commercials, which I think I'm going to have one in this slideshow here. Anyway, also under establishing condominiums on page 127, in New Jersey, the creation of condos is regulated by the state's Horizontal Properties Act as well as the Condominium Act of 1970. All right, so this was a screenshot from the previous book where they had it on 2 different pages, but now all this is on 1 page. So it's just all together. That's just the difference. I just got to upload these. But you're highlighting the same thing. So to establish a condominium, first the owners of a property execute and record a master deed, and they file it in a public record in the county where the land is located. Many items have to be contained in or attached to that master deed, including legal descriptions of the land itself, any graphic drawings or descriptions of the buildings and other improvements, which identify the individual units by letter, name, or number, or combination of them, and specifies a percentage of the common elements, if any of them are going to be included in the ownership of each of the individual units. A description of common elements, provision for an association of unit owners, and a starting out list of bylaws for that condominium. When you buy a condo, you receive a deed for fee simple ownership of 2 things. Everything in your living unit from the paint on the interior walls inward, and a proportionate undivided interest of those common area elements, those shared elements. Okay, so what does this mean from the paint on the interior walls inward? Well, they don't want you breaking open walls when doing remodeling and tapping into the plumbing, which is shared and used by all the unit owners there. You need to get permission from the HOA, and probably their maintenance guys are going to need to do any tapping into plumbing if any modifications are going to get done. So the HOA is a homeowners association. Remember, all unit owners are going to belong to that. Bylaws set up these CC&Rs, covenants, conditions, and restrictions, which all the property owners need to follow. These are all the rules and regulations. And if you don't follow them, they could issue fines. Now, bylaws could be different. Sometimes you could have new construction of condos, and then other times you could have an apartment building that was converted to condominiums or a multifamily house. Now, rules that can prohibit a for sale sign or painting your front door a wacky color or saying that there's no oversized or commercial vehicles allowed in the parking lots, or no decorations in a flower pot is the way that they got away with forbidding people to hang an American flag from their balcony. You know, sometimes you get people, they put a flag in their flower pot and they say, hey, that's my, decoration, because we're allowed decorations. So then they say, no decorations in a flower pot, no flags, no things like that. Car wraps, sometimes you get vehicles with commercial car wraps on them, things of this nature. At what point does it become unreasonable? Not allowing you to have a bumper sticker on your car, maybe? Isn't that free speech? Well, if that's part of the rules, and you weren't there to vote for the rules and you left it up for the HOA leaders to do, and it was voted on and passed, well, guess what? You got to obey the rules. On the next slide, or one of the coming up slides, we're going to go over a goof commercial on TV that I copied here. Where they goof on condominium HOAs where they get power hungry and it goes to their heads. So the HOA fee is the monthly fee that all the owners will pay for the maintenance of those common area elements, to cut the grass, do the landscaping, do the snow removal, maintenance of the pool and the exteriors of the building, trimming of trees and such. It's managed by condos are managed by a HOA board, but professional management is usually hired if there's more than 25 units, but not always. You guys ever see this Geico commercial? Oh, let me jack up the volume a little bit so you could hear it here. But you know what? Sometimes stereotypes and such are rooted in some factual things that actually go on. So let's watch this. By the way, look at the architectural structure behind them. They're living in a condominium complex. This looks like a single family detached house, as they are in the neighborhood here. And they're maintaining their own exterior of the property. Some condos, the HOA doesn't maintain the grass, or they require the tenants to maintain the grass and such. Usually that's around where they have single family detached houses in those kinds of situations, or it's a small condo complex with like 2 units or 4 units. Otherwise it's usually the HOA that deals with the landscapers and such. But check this out.
We love our new home. The neighborhood's great.
Amazing school district. The HOA has been very involved. These shrubs aren't board approved. You need to break down your cardboard.
See them walking around with their clipboard and checking things out, all in people's business.
Thank you.
Violation. Violation.
I see you met Cynthia.
At least Geico makes bundling our home and car insurance easy.
I think that's how us save a bunch of money.
George is over regulation.
Except for bundling made easy, go to Geico.
I mean, even Geico's goofing on these things because they are real. This stuff does happen. And look, I got a couple more examples over here of them. Here's one from on the Realtor website. HOA forces homeowners to leave garage doors open during the day. Could you imagine? What do you keep in your garage? Anybody here got a garage? If so, what do you keep in your garage?
Car.
You got a car in your garage? Okay. Any other stuff you keep in the garage there? Anybody got a garage that's full of stuff? You just like a storage place? It's like the
lawn chairs.
it's like the armpit of your house, right? So, I mean, can you imagine having that door being required to be open all day? I mean, well, isn't that a security issue? Sometimes there's a door leading from the garage directly into the house. Doesn't that give an opportunity for thieves to come in or to try to break in? Well, you had a condo association that did that after they found out that some residents had finished their garages and then they started renting them out for people to live in. And that became an argument. And then they would fine residents several $100s a day if they didn't leave their garage doors open. Or how about this one? Here's another news article from Realtor.com. It shows you that an HOA forced me to buy a $500 mailbox. A little bit extreme. Well, this guy fought it in court and he was able to win. But, check this one out here. There you go, $500 mailbox. He battled his HOA for over 7 years not to pay for a $500 mailbox, and he won. Yeah, over $500 though. I hope they paid his legal fees.
Yeah, I was about to say, was it worth it?
Yeah, was the juice worth the squeeze on that one? I hope they got him to pay the legal fees on that too. So, yeah, it's crazy because look, if they require you to have some kind of, everybody has to have the same mailbox, a fancy mailbox that they install, and it costs a lot of money, I mean, look at this guy. This guy, see, a solar physicist with NASA. He paid $35 for a charming and functional cedar mailbox just months earlier. But he wasn't buying the line that the condo association gave that said that the community was looking run down and everybody had to get this new and homely looking cast aluminum model costing $500 pictured below. That's this one. $500 for this mailbox. So he paid for one $35 that looked rather charming, as he said, but I don't see a picture of that. But either way, he fought it in court and he won. But there's all kinds of out of control deals and things like this. Let me see. Care about President, we just got a new roof on our house, cost over $100,000. What would stop an HOA from coming back and saying, we don't like the cedar roofs that you put on? So he actually sued the HOA, let me see, for $1. Some said we were trying to bankrupt our HOA, but we actually only sued them for $1. We wanted the board to admit that they were wrong. All of which provokes the question, what are your rights as a homeowner? You got to be careful when buying into homeowners associations, when buying into condo complexes. I tell people, I used to deal a lot of condos. I sold a lot of condos. That was like a specialty of mine. And they've got their nuances to them too. But I learned that's where I was making most of my sales, and I was making a lot of money off of selling condos. Of course, I was trying to get those rich, expensive mansions and such, but, those people didn't want to deal with me. They didn't want to deal with other rich people or those that lived in the area that had their real estate licenses. So anyway, I found I was making a lot of my money dealing with investors, multifamily houses, fixer flippers, and condos. Condos was actually my breadwinner. So I said, you know what? Let me focus on that. And I learned a lot. Like, you could have 2 condo units in the same building, and they look exactly the same, and one costs significantly more than the other. Why is that? Sometimes you could have one that comes with a deeded parking space that you own, and the other doesn't. Some of them may have a separate storage place in the basement. They have like a 10 by 10 room in the basement for storage, but the other one doesn't. You have to really dive into the details. Some of the stuff you may not catch on to until you're in the business for a little while. So you got to ask the unit owners, is there anything unique about your unit that I should be aware about when trying to value your home? Okay. And then they'll point out the differences because they were shopping when they bought the unit. They know the differences of what's going on with the different units there. Trust me on that. They do. All right. But yeah, these are some issues that we come across. A lot of times when people sell condos, sometimes they're selling them because they need to upgrade, get a house, they got a growing family or whatever. But other times they love it there. They just hate the management. So they're getting out of Dodge because they got managers like Cynthia here, all in your business. I've dealt with these. If you ever have apartment buildings that were converted to condos, one issue with them, I'll tell you right off the bat, they usually don't allow you to have a washer and dryer in your unit because those buildings were not originally made with the plumbing sufficient enough to handle the additional stress from a washer and dryer in everybody's unit. They usually had a common laundry room, so they don't want you to have that because it puts a strain on the plumbing there. And because it wasn't built for that. I remember that I was selling a condo for somebody, and the guy was like pointing out how he's got a brand new washer and dryer over under unit in the closet over here. And I was like, oh, cool. So I took pictures of everything. I put my advertisements out there on the, in the MLS and then online in different places. He forwarded me an email that he got from the HOA threatening to fine him and wanted to get in his unit for inspection because they saw a picture in his unit. They were trolling the real estate websites. They found his unit listed, and they circled, they printed it out and circled a picture of the washer and dryer and said they wanted to inspect the unit. It's not supposed to have that in there. And so I took that down really quick, those pictures, but he never said anything to me that we couldn't have that there. So that's why it was there. It was an honest mistake then, because he never mentioned anything that he couldn't. But this is something that a lot of people actually do. So that's another thing to look out for and be aware of. All right. Anyway, so condos, creation of condos are regulated by the New Jersey Horizontal Properties Act and the Condominium Act. Certain tenants may not be evicted during condo conversions. Owners of condos have income tax advantages identical to those of single-family homes. And condos can be any architectural style, even single-family detached houses like you've seen in that commercial right there. Multi-unit attached housing, high-rises, garden apartments, or townhouses. The difference from a condo arises from the form of ownership. It's fee simple ownership on everything from the paint on your interior walls inward and a proportionate share of the common area elements. Sometimes we get people, they call up and they say, yeah, I want to buy a townhouse, but I want none of those condos. I don't want to worry about cutting my own grass or doing any repairs because I'm not good at that. Okay. That doesn't make sense. However, I know what people are talking about when they say this. They're basically saying they don't want the apartment building style condos. But they do want a condo because they don't want to maintain the snow removal and the landscaping and such. And a townhouse is an architectural style. It's attached housing that is multi-level attached housing, usually with a garage under it. Not always, but usually. So that's what the architectural style of a townhouse is. Townhouses can be simply fee simple ownership, but they could also be condominium ownership. Fee simple ownership with the condominium HOA rules, those CC&Rs you need to follow. Reserves is an amount of money saved up for emergencies and repairs. And whether it's a condo or a co-op, usually they have extra fees built into them that beyond the actual cost to maintain the common area elements. It's so that they could build up a reserve fund for emergencies and repairs that could possibly happen. Maybe the condo complex gets sued. That's an emergency for a legal fund that they need to cover. Maybe they have more snow this year than we had the last, so they're going to spend a lot more money for snow removal. Maybe they're got to replace some roofs on some of the buildings, so on and so forth. Now, when buying in a condo complex, we always ask for a copy of the CC&Rs, the rules, those bylaws, and we ask the condo association for a copy of the last 2 to 3 years financial statements. And so what are we looking for in those financial statements? Well, usually we turn it over to an attorney and they do the looking, but just so I can give you guys a heads up so you're more educated. What is the attorney looking for then? Which you could also look. Whatever the costs are to manage the association on a monthly basis, that association should have a minimum of 2 to 3 months reserves in their account, in their reserve account, to pay those fees. So if they didn't get another penny in for the next 2-3 months, they could still run the complex. At minimum, they should have that. If they don't, you could tell they're mismanaging it. sometimes you have these people that are appointed to the HOA, board that now you see somebody was appointed and they're like, my husband owns a landscaping business. Let's get him as the landscaper for the complex. Boom. Oh yeah, well my wife is an attorney. We should have her as the attorney on what do you call it? On standby, or the attorney on I forget what they call it, where they pay them a fee just in case they need to consult with them.
Retainer, right?
Geez, I forget. There's a word for that in my
Retainer.
A retainer. There you go. We should have her on retainer. Now, are they shopping around for the best services from the best candidates that are offering these services? No. This is nepotism, where they're getting the jobs because they know somebody. So they're not shopping around getting the best prices or necessarily getting the best people to perform those duties. So when that happens, often fees go through the roof. The expenses, the spending gets careless, just like with politicians and what politicians do. So what happens is, if you don't have a minimum of 2 to 3 months reserves in the account, in the reserve account to maintain the association, you know that the monthly association fee is going to be going up sometime in the near future. So whenever buying into a condo complex, you want to look at those financials to make sure that that's not happening. Otherwise, you could predict right off the bat if they're going to be going up or not. And you want to make sure there's no lawsuits that are currently going on. And you want to make sure that, you want to know what the rules are by finding out what the bylaws are. Okay, so that's my tip of the day for you. All right, so what's the difference between a condo and a co-op? Well, in a condo, you own real estate. In a co-op, you don't. You have stock and you get a proprietary lease to occupy the unit. You get a mortgage bill with a condo. Co-ops, it's a cash or personal loan. You get a tax bill with condos. Co-ops, you don't, because those taxes, you don't own the property. The corporation that owns the property pays the taxes. But that fee is built into the monthly maintenance charge. That's why the monthly maintenance charge is higher. So I just abbreviated it here and called it an HOA fee. So condos, they get that HOA fee. Co-ops, it's higher. HOA application and approval process, not for condos, but yes for co-ops. Minimum credit score requirements, not for condos, yes for co-ops. The management in a condo is by an HOA. The co-ops, it's by a board of directors. Remember, it is a corporation, and corporations are managed and operated by its board of directors. But each of the individual stockholders, those unit owners, they have a say in the management. Insurance, condo owners got to pay their own homeowners insurance for their property. Co-op owners, well, they pay renters insurance. Condos can be rented. Co-ops only in certain circumstances. If they got a complex with 10 or more units, they've been trying to rent it for 4 or more months at a price no greater than what they bought it for, and they're unable to, then they could rent it. Income tax advantages are identical for both. And if enough people do not pay their monthly HOA fee, can it affect your neighbors? Not in a condo. Individual units can be foreclosed upon. In a cooperative, yes, it can. All right, so if we buy an apartment building or a multiple unit house, we can convert it to condos. We call that a conversion or condo conversion. So a conversion is when you convert an apartment building or multi-unit building into a condo by deeding each unit separately for sale and then creating an HOA, the bylaws, CCRs, etc. Creation is regulated by the state's Horizontal Properties Act, and it requires approval 3 years and 2 months before the conversion may start, if it's not vacant. Certain tenants may not be evicted during condo conversions. If they meet all these requirements, then they may remain as tenants for 40 years. People who are age 62 and older, or certain disabled persons, if they lived there for at least 2 years before the conversion began, and their income is no more than 3 times their county per capita average income, or in any case, no more than $50,000 a year. If they meet all 3 of these requirements, then they cannot be evicted during a condo conversion and still have to be allowed to rent units there. So they could remain as tenants for the next 40 years. See that? So if they're 62 years of age or older, you can't kick them out till they're 102. And then you're just mean. All right. So let's highlight that on page 127 under condo conversion. You know, there's something in this book, in this version book, there's a sentence actually right underneath this condo conversion one that says, remember, condominium owners receive a deed and therefore own real estate. Co-op owners receive shares of stock and a proprietary lease, both of which are personal property and therefore technically do not own real estate. May not be a bad idea to put a box around that with your pen for that last sentence.
Okay, got it.
I'm going to see about putting that into the slideshow here too. There.
Okay.
Call it condo versus co-op. So upload that. What is chapter 7? Right, so all right, so I just added this down here. So we just put a highlighted box around this sentence below condo conversion as well. So you understand that when you own a condo, you own real estate. When you own a co-op, you own stock and a proprietary lease, which is not ownership of real estate. Townhouse is an architectural style. So we highlighted the term townhouse is used to describe an architectural style, which buildings share a common party wall. Townhouse is basically multi-level attached housing that shares a common party wall separating the 2 units. And townhouses is just an architectural style. It's not a form of ownership. It can be fee simple ownership, or it can be with a condo association, which has rules that you need to follow. So condo association is fee simple ownership with condominium CC&Rs you need to follow, rules you need to follow. Kind of like the fee determinable estates have, except it's not considered a fee determinable estate because these rules are created and changed often on the fly by the HOA. So condo is a form of ownership. The townhouse is an architectural style. It's important to understand the difference. Probably get an exam question or 2 on it. So many townhouses are, in fact, condominiums more often than not. A condo is that form of ownership. It has an HOA in charge of maintaining the common area elements and the exterior of the building. And they have rules the owners must follow, those CC&Rs that are set up in the bylaws. Those covenants, conditions, and restrictions. And a townhouse is simply just that architectural style. It's not a form of ownership. It's multi-level attached housing, shares a common party wall. Townhouses could be, like I said, fee simple ownership, and just straightforward fee simple ownership without a HOA. But often they are condos. So the owner doesn't have to cut their own grass or maintain the exterior of the building, the roof, etc., the landscaping. So they could simply also be fee simple ownership without the HOA. Here's an example of a small townhouse complex. It's actually just a row of them, maybe about 10 units here. These ones here are about 100 years old, a little bit over 100 years old, I think. They're from my town. I snapped this picture on Stiles Street in Linden. You could see in condominium complexes, they generally want you to have everything uniform, because uniformity maintains a good visual appeal and it maintains its value better. These are townhouses that are not, there's no condo association here. It's fee simple ownership without a HOA. So as you could see, you got 2 units here. They share the same color. They're brown over here on the edge, or beige. One's got dark brown, one style of wood stairs and railings, and the other one, it looks like it's wood stairs with maybe a vinyl railings. This building over here, it's yellow. Now look, sometimes townhouse complexes, even if it is a condo complex, condominium ownership, they may have alternating patterns between the units, you know, but it'll look really nice and neat and it'll be uniform. This is not that. Look at this. You got 2 units here. They're both yellow. Different kind of look about them. Different roof. Different front door styles. Different. Well, they share the same staircase. Then it alternates to this unit, which now you got a green next to a beige. Different color, different types of roof shingles. You know, this is definitely not a condo. You know, the book tells you that usually you cannot tell if it is a condominium simply by looking at it. Sometimes you can, like right here. Here's another view of it from the other end where you can see all the units here. Some units, look at this one, it's got overgrown brush over here. It's got something, a little lattice down the bottom that's broken off. Different roof styles, different types of shingles, different colors. It's not really alternating. There's no rhyme or reason to the alternation of the color or the materials of the siding. This one even has 2 different types of siding on the one unit. That's not going to be a condo association there that allows that to happen. Some units have the grass cut. This one doesn't. Some do, you know. All right, so time sharing. What is a timeshare or time sharing? Now, this is a screenshot from a different version of the book. I just got it all on one page here versus the this version book, which is split between 2 pages. That's fine. This is on page 127 and page 128 now. So I want you to write next to the title, time sharing is a form of shared ownership. Is a form of shared ownership. Now, I'm not going to read through this. Instead, we're going to watch a video or a couple of videos that explain timeshares and what they are. However, New Jersey timeshare law does apply to all timeshares sold in New Jersey as well as those located outside the state. The act requires certain disclosures be made when certain types of out-of-state properties, such as subdivided land sales, condominiums, and common interest ownership properties, are offered for sale in New Jersey. Highlight: a timeshare buyer has the right to cancel timeshare contracts up to 7 days after signing the contract. That's a right of rescission with the new construction for out-of-state properties offered to New Jersey residents or those in-state subdivisions for new construction. The buyer may cancel certified mail or in person, whereupon the seller must refund all the payments within 30 days, too, if they made any payments. So only these first two are on page 127. Let me see if I got a... So it's page 127 up here. And below this is 128. It goes on to say that the developer or timeshare salesperson is required to provide honest, not false information, to not make any predictions of increases in value or misrepresent how the buyer may use or exchange timeshares. The New Jersey Real Estate Timeshare Act does not apply to 10 or fewer timeshare interest investments of less than $3,000 or to resales, only for new construction of timeshares. The Bureau of Subdivided Land Sales Control is another division within the Real Estate Commission. It's actually one guy, but there's it's a department within the Real Estate Commission that before any new construction for a timeshare in New Jersey or in another state that's offered for sale in New Jersey can be offered for sale, they first need to submit a package to the Real Estate Commission or the Subdivided Land Sales Control Bureau so that they could confirm that it's a real project. That you don't have scam artists trying to sell you swampland in Florida, something like that, and so they need to submit a package with certain information about the buildings, what the project's plans are, proof of insurance and funding, and they also need to provide a plane ticket and accommodations for an investigator to travel there to make sure that the site actually exists and the project is actually a real thing before they could actually offer it for sale in New Jersey. So keep in mind, if you're a real estate agent, before you go start marketing any out-of-state properties, new construction like this, you better make sure that it's registered with the Real Estate Commission first, or I'm sorry, the Bureau of Subdivided Land Sales Control, which is a division of the Real Estate Commission. It's actually one guy. Pretty kick job, wouldn't you say? His job is to fly out with all expense paid destination resorts to examine paperwork, but that's basically his job, traveling a lot. Not a bad gig, huh? So time sharing is a form of shared ownership. It's ownership of real estate for a short period of time each year. You own it, you own the unit. It's like you buy a condo, but you own it for 52 weeks in a year. You own that condo for maybe 1 or 2 weeks, or maybe even a month out of the year, and you're splitting that shared time with other owners. So you're buying a specific week or time frame during the year. I've seen these timeshares offered on cruise ships too. Yeah, let's take a look at let's look at the penalties first. If you violate the laws of anything that I've explained there pertaining to timeshares already, about explaining how the values could go up or how you could trade or exchange them, or, if you do any false or misleading advertisements or make statements. The minimum penalty is $250 with a maximum of $50,000 per offense for out-of-state subdivided land and timeshare sales violations, which are covered under 4515-6.50 to 4515-16.79 in the, what is that? 4515. That's New Jersey statutes. That's the laws of the state. But these are the ones pertaining to timeshares. All right, here's a couple of videos for you. You guys all here, by the way? Here, let me throw out the afternoon after lunch attendance poll. All right, let's watch this time sharing video. You guys probably saw this commercial on TV or heard it on the radio at some point in time. You may recognize the guy's voice.
If you bought a timeshare for your family, by now you've learned the ugly truth. Timeshares are the only thing that you can buy that you don't know how much it's going to cost or when it's going to end. It's like giving them a blank check for annual maintenance and assessment fees. Sounds crazy, right? The ugly truth is that this never ends. Hello, I'm Chuck McDowell, and 10 years ago, I founded Wesley Financial Group with one goal in mind, helping good folks just like you cancel their timeshare contract. And what that means for you and your family, no more mortgage payments, no more maintenance fee surprises, and no more timeshare. So call today.
All right, so
If you bought
all right, so we're going to learn a little bit about timeshares. There's a 3-video series here. They're real short video clips that talk about timeshares to educate you what they are. And that's created by his company. That's what's going on here. You guys may have you guys probably will at some point in your careers have people come to you wanting to sell timeshares and see if you can list it for sale for them. My advice to you is probably don't. They're a major pain in the butt, and you probably don't have the knowledge or resources available to sell those timeshares. Usually in the past, what I've done is I just referred people, I just gave it as a referral to one of these timeshare sales companies, which usually just get a flat fee, and they list the property for sale on their timeshare site. Anybody who ever buys timeshares, they're probably better off getting them through one of these timeshare resale sites, because you could probably buy them, that same timeshare, instead of buying it with new construction, you could probably buy it for pennies on the dollar when people are just trying to get rid of timeshares that they no longer want. So that's interesting little factoid there for you. I'm just adjusting these slides a little bit. And then we're going to watch them right now. All right, so let me back up, go back into it. And without further ado, let's watch.
We have a consumer warning to tell you about this afternoon for anyone who's trying to sell a timeshare.
Probably heard horror stories of folks going into a timeshare sales pitch and being stuck there for hours.
The maintenance fees were going up 12.5% every single year.
This is the Great American Timeshare Scam. Like most bad things, timeshare started out with really good intentions, but greed, deception, and manipulation has distorted this once creative tool that helped families vacation and turned it into a lifetime of debt for millions of families. In the 60s and 70s, timeshare was a brand new, innovative way to fund property development. And for a while, the system worked. Resorts popped up everywhere, with families owning fixed-week timeshares at a reasonable cost. So what changed? Timeshare companies became obsessed with the bottom line. Profits, money, commissions. Oh my. And now, this steal of a deal, own your vacation, you just bought a house scheme is bribing people to attend sales meetings and deceiving families into a loan that can never be repaid. Thanks for watching. This was actually just part 1 of a 3-part series on the most deceptive practices within the timeshare industry. If you're interested in learning more, watch part 2.
We're going to go over all 3 of those parts right now.
The dark psychology.
Go over the other 2, the dark psychology of timeshares. And sales, it does have a psychological aspect to it sometimes. And timeshares, these salespeople are usually highly trained.
You own your house, why wouldn't you own your vacation? Deals like this come once in a lifetime, and you won't have access to it once you step out of this meeting.
If you've ever sat through a timeshare presentation, you've likely heard this phrase or something like it before. This technique is called the exploding offer, or what is more commonly known as FOMO. And unfortunately, it's not the only technique they're using on you to make the deal. This is the dark psychology of the timeshare sales meeting. So, how do people find themselves in awful timeshare situations? Simple. Timeshare salesmen understand humanity's dark psychology. For example,
if you don't do this now, this deal may run out and be gone forever.
What does your brain instinctively want to do now that you've heard this?
Do it before it's too late.
This tactic is known as the scarcity effect. Scarcity pushes people to make impulsive decisions like buying up all the toilet paper during a global pandemic because...
What if we run out of all the toilet paper?
Right. Very rational. We're not going to go too far down that rabbit hole, but generally a feeling of regret follows impulse buys. Stop me if you know it. Buyer's remorse. Another example is the law of reciprocity, where people feel obligated to stay for the sales meeting because they were given free tickets to an event or a free dinner. This is why they... Watch the glass. This is why they bribe people to come to the sales presentation, because it makes people feel like they should give back their time in exchange for these gifts. And these are just a few examples of the dark psychology timeshare salesmen use. They are masters of persuasion. This is why it's so important to be aware of the psychological influences that affect decision making. That way, you never find yourself in a timeshare presentation to begin with.
Ready for vacations for life?
Keep on walking, pal. Thanks for watching, and stay tuned. You just finished part 2 of our 3-part series on the deceptive practices to look out for in the timeshare industry. The next video is the timeshare contract. In that video, we go over why the timeshare companies will pressure you into that first sale, because once they've got you, they're not going to let you go, at least not without a fight.
You own your house.
So here's the timeshare contract. This tells you a little bit more about timeshares.
Timeshare is an investment. You'll be able to rent it out. You'll be able to travel anywhere you want for life. This is the timeshare contract. I'm going to save you the heartache and explain why the timeshare companies try so hard to sell you timeshare. Because the first sale is just the beginning of the ultimate con that's about to destroy your finances. Let's start with the low-hanging fruit. If they can convince you to buy a timeshare, they're guaranteed consistent yearly income without having to give you anything but imaginary points. What a deal for the timeshare company, right? Free maintenance paid for by you for their property that they actually own. They're called maintenance fees, and they go up every single year. A big fat commission because timeshare barely costs the company anything. Seriously, sometimes that salesperson is getting over 30%. And get this, once they've got you, it's nearly impossible to get out. If you try to cancel, they'll tell you they can't do anything. You signed a contract. They may even tell you to sell it yourself. They definitely won't buy it back. They don't want it, and they know it has no value. But if you try to sell it, it turns out no one else actually wants to buy it either. Spoiler alert, there is no market for timeshare resales. None, zero, zilch, nil market for it. Look at this eBay listing for a timeshare. For $1. We've even seen people offer gift cards to take their timeshare. No, I'm good, man.
But it's an investment.
Get out of here! What's crazier is that these timeshares still won't sell, so families are stuck in the timeshare scam, paying all their outrageous fees. And then, when they finally had enough, they're out more money for another service to help them get rid of it. Now, hypothetically, hang with me here, let's say you actually did get that timeshare sold. This means someone else now has your timeshare, which is perfect, right? You no longer have to deal with this financial burden. But there could be a catch, and we've seen this happen over and over. If the person who bought your timeshare stops paying and the timeshare company comes calling, guess who could be on the hook for all of that debt? Yep, the original owner of the timeshare. Oh, shh. And I say this to really show you how hard getting out of a timeshare is. There are plenty of other stories and examples of this kind of unfortunate situation, but I think you get the sad point. Oftentimes, once an owner has tried a couple different avenues to get out, they begin to lose hope. This is what the timeshare companies count on. They want you to sit down, shut up, and pay them your money without actually getting anything in return. They seem more like a mafia than a reputable business.
I'm going to sell you a timeshare you can't refuse.
But thankfully, you don't have to be hopeless. It seems like one of the only ways you can actually cancel your timeshare and all its related debt and fees is through a timeshare exit company. It isn't easy, and it can take up to 3 years, but it is possible. The only caveat per se is that it needs to be a reputable company. There are a few good ones out there, but as these timeshare exit companies have gotten bigger, the timeshare companies have actually started suing them into oblivion. We know this for a fact because they sued us too, but we beat them in federal court for the right to help people like you get relief from the burden of the never-ending lies and fees. This video series only scratches the surface on the most deceptive practices within the timeshare industry. If you want more videos like this, hit that like button. And if you have experienced any of these tactics yourself, tell your story below. It helps people understand that they are not alone, and the situation they found themselves in is nothing to be embarrassed about. Also, if you haven't seen the other videos in this series yet, make sure to check out The Great American Timeshare Scam and The Dark Psychology of the Timeshare Meeting. What you discover may shock you.
It's a pretty good little series, quick to the point. It's hits the details of what you needs to know, or should know. Okay, now here's a few common architectural styles that we need to be aware of. Because when you get listings and you put them into the MLS, one of the required fields is that you need to show what is the architectural style, what type of property are you selling here. There's a lot of, let's go over some residential architectural styles. You could try looking up architectural style guides and you get a lot of stuff. Maybe you could find one for realtors. This is something I've been working on trying to put together as well. There's one here on Realtor Magazine. It's okay, but not so great. But either way, here's some of the common architectural styles that we come across in real estate here. And we got our Cape Cods, Colonials, Victorians, ranches, raised ranch, bungalow, split level, Tudor, contemporary, bi-level, townhouse, duplex, which is a two-family side-by-side, or an over-under, which is a two-family, one unit above the other. These are some of the more common architectural styles you see in New Jersey, but these ones can be found here as well. Just not maybe as common, but you could see some of these like the Dutch Colonial, Federal, Georgian, Monterey, Gothic, Greek, Queen Anne's maybe, high rises and apartment buildings. But Art Deco, Craftsman, Saltbox, these you may come across. Everybody here know the difference? Here's some of the most common ones. Cape Cod, Colonial, Victorian, Ranch, Raised Ranch, Bungalow, Split Level, Tudor. Wow. Bi-level. You guys know what the difference is between a Cape Cod and a Colonial?
No.
I mean, they both got basements. Cape Cod, usually the second story is got a pitched roof to it. Sometimes they have dormers on it, that are built out. colonials, these are larger. You could have older style home, but you could have newer ones that are colonial style, where all the living space is on the main floor, your kitchen, your dining room, your living room, family room. Typically, bedrooms and bathrooms are found upstairs. Sometimes you could find one bathroom on the first floor. Victorian, the difference between a colonial and a Victorian is Victorians are much larger than colonials. They usually also have wraparound porches around the house, and their doors and their hallways are usually much wider and taller. The fireplaces are taller. They have very artistic wood designs and carvings. It's from the Victorian age, the Victorian era, where everything is very ornate. They're very beautiful. You know what a ranch is? It's a single-story house. So you don't have a lot of stairs you need to be climbing up. But sometimes you got a raised ranch. That means it's above the ground level, Raised ranch is usually ones that have basements. Sometimes ranches have basements, sometimes they don't. Raised ranch, the basement is partially above the ground. So therefore, you probably have to climb upstairs to get to the front door. Bungalow, a bungalow is kind of like it's a narrow, long house. Kind of looks like an army barracks, I guess. Split level, you got stairs going up to the front of the house, but every room, you got to go up or down a couple of stairs. It's not a huge flight, but it's a couple of stairs. All the levels are split. Tudor can be very ornate, and they can be very beautiful. The smaller Tudor-style houses are very awkward, though. You got to climb up the stairs going upstairs, and the roof is probably pitched, and you're hitting your head against the ceiling. But the larger Tudors are very nice. They have a very unique look about them on the exterior of the building, though. Bi-levels, just like it sounds. Bi is two. It's a two-story house. However, there's usually no basement, and it's sitting on a concrete slab. If there was a basement to it, it'd probably fall into the category of a colonial. And then, of course, townhouses. These are multi-level housing that's attached. Let's take a look at the architectural design guide that the Realtor magazine has here for some of these units. Bungalows, Art Deco, Cape Cod. This is one look of a Cape Cod. I live in a Cape Cod, so if you guys came to my house, you saw what I have, but I have an attached garage, but they could have attached or detached garages. They have a basement, they have bedrooms upstairs, maybe even a bathroom upstairs, but bedroom, kitchen, dining room, bedrooms on the first floor, have a basement, and some on the second floor. And there's several different designs of these, so you could have quite a few designs. And my roof is pitched forward, not to the sides like that. Colonial, contemporary, craftsman. Not a bad idea to just start looking up some of the architectural styles. These are just drawings. Salt box, ranch. It's a single-story house. These actually are pretty decent in value, though, but you require more real estate in order to have them. Tudor style. All right. And then at the top over here, you also have architectural structural elements that you could click on. Most complete code of ethics training requirement by December 30. Well, they're kind of throwing that on us last minute, aren't they? I think I already took care of that, though. But let's see. Architectural style, structural elements. Let's talk about the arches. You're giving you the different types of arches over windows. It could be flat, Gothic, Moorish look, Romanesque, segmental, Tudor style. Types of columns based on the designs. Corinthian, Doric, Egyptian, Ionic, Romanesque. Types of dormers that stick out of the roof. Hipped, gable, eyebrow shape, inset, shed. Types of molding designs. Roofs. Cross gable, front gabled, gambrel, looks like a barn. Hipped, mansard, pavilion, salt box, side gable. Window style, you got bay windows, bowed windows, box bay, casement windows, double hung. You get the idea. This is not the greatest guide here, but it's better than nothing. There you go. Here's an architectural style guide for everybody. And that concludes chapter 7. So let's do the key terms to review. There are 2 key terms to review, no edits to make, so let's get into it. Key terms to review 1 on page 129. Ownership.
Title.
13 is A, title. Title is another word for ownership. A default form of ownership for those who are unmarried and not in a civil union. In other words, a type of ownership for 2 or more people or entities that are not married.
Tenancy in common.
Correct. 11 is B. Person named in a will to inherit real estate. What do we call someone who's named in a will to get the real estate?
Devisee.
The devisee, 2 is C. A group with each partner completely liable. They're talking about businesses here, partnerships particularly.
General partnership.
A general partnership, 3 is D. Isn't that kind of interesting, though, how they modified the book, this version book, and they say general partnerships have no general partners, but yet over here it says the group where each partner is completely liable. You know, that would be a general partner that's completely liable. Book makes mistakes, too. So a non-married, so 3 was D. A non-married person with the right of survivorship, someone who's non-married that has the right of survivorship.
Right? No, they wouldn't have it be the same thing.
No. So a non-married person with the right of survivorship. Who has the right of survivorship? Sorry, Alexi, you were saying something?
Joint tenancy.
Yes, joint tenancy. 4 is E. Joint, the sole benefit, the only benefit of joint tenancy is the right of survivorship, right? So 4 is E. A business owned by one person or entity.
Sole proprietorship.
9 is F, correct, sole proprietorship. Co-owners join together to carry on a business.
Partnership.
7 is G, a partnership. Court-ordered sale and division.
Partition.
A partition, 7 is G. Court-ordered, okay, D, I'm sorry. 7 is G, partnership. Okay. That was co-owners joined to carry on a business. 7 was G, a partnership. Court-ordered sale and division was what?
Partition.
A partition, 6 is H. Legal entity considered to be an artificial person.
Corporation.
1 is I. A process by which co-owner automatically receives share of a co-owner who died. What do we call the process? Process by which a co-owner automatically receives the shares of a co-owner who died.
Right of
The survivorship.
Correct. Right of survivorship. 8 is J. Special ownership by married couple.
Tenancy by the entirety.
Tenancy by the entirety is correct. 10 is K. Real estate ownership by only one.
Tenancy and
Several. Yeah, it's like it sounds. Severalty.
Severalty.
Yeah, tenancy and several, like many, several, like or
Severalty.
few, severalty. Even though the root word is sever and not several, it's pronounced severalty. Correct.
Severalty.
12 is L. And a group with only the general partner fully liable.
5, limited partnership.
5 is M, the limited partner. Okay. And then key terms 2 is on the next page. Co-op owners' right to the specific apartment. What gives them the right to occupy the unit that they're living in?
Proprietary lease.
Proprietary lease, correct. 8 is A, the proprietary lease. It's a fancy word for custom lease. Yeah. A group elected to manage a cooperative.
Homeowners association.
A cooperative. Who manages cooperatives?
Board of directors.
1 is B, the board of directors. An architectural term. Hell, there's a lot of architectural terms, but what do we call one that's multi-level attached housing?
A townhouse.
11 is C. Stairwells, roofs, etc., owned by all.
Cooperative, right?
No, what do we call the stairwell?
Common elements.
They're the common elements, correct. 2 is D. Apartment whose buyers receive proprietary lease and stock in a corporation.
Cooperative.
That's a cooperative. 5 is E. Fee simple ownership of a living unit.
condominium.
Condominium. 3 is F. All owners in one condominium complex. All the owners in a condominium complex.
Homeowners associate.
To which all will belong. Correct. 6 is G. Apartment house changed to condos.
Conversion.
It's a conversion. You converted it into condos. 4 is H. Money set aside for future repairs.
Reserves.
9 is I. Ownership for only part of a year.
Oh, timeshare.
10 is J, time sharing. And regulates the creation of condominiums.
Horizontal Properties Act.
The Horizontal Properties Act. 7 is K. That is correct. And that concludes Chapter 7.